court. My name is Sarah Pellenbar, and I represent the Appellant City Center and Dr. People in here in Patel. The issue here today is whether the trial court erred in awarding attorney's fees in favor of JVR&K, and there are three arguments I'd like to make. The first is that the trial court erred as a matter of law in applying Rule 1.525 and in finding that JVR&K's motion for attorney's fees was timely as to both the February 6th and the February 9th judgments. The second argument I'd like to make is that the trial court had no authority to make City Center and the Patels jointly and severally liable for all of the fees expended in this consolidated case where City Center was not a party to the Patels' declaratory action and the Patels were not a party to City Center's foreclosure action. And the third argument I'd like to make is that there's no substantive basis.
And before you get started with those arguments, that because it's a consolidated case, there are two doctors named Nandagam and a person named Voletti, who I believe are parties below.
Correct. And in fact, a separate order has been entered in favor of the Nandagams awarding their fees.
But they're technically parties to this appeal who've made no appearance then?
The court ended up issuing two orders granting attorney's fees. It issued one order in favor of JVR&K. At the hearing on the motion for attorney's fees, the opposing counsel canceled the hearing with respect to the Nandagams, and they requested an enlargement of time. They did not request an enlargement of time with respect to JVR&K. So the court's order on JVR&K's fees was issued before the court's order on the Nandagams' fees was issued. The Nandagams have separately appealed that fee award, and we moved to consolidate that case with this case, and that was denied.
But they were too far apart in timing.
Correct.
Right. Okay.
The first argument I'd like to make is that JVR&K's motion for fees was untimely. Rule 1.525 provides that any party who is seeking an award of attorney's fees shall serve their motion for fees within 30 days of final judgment, which judgment or notice concludes the action as to that party. The words "shall serve" are mandatory language. It's in derogation of the common law, and it's strictly construed. And in fact, the recent Florida Supreme Court cases of Sciamotor Freight Line.
Why is that rule in derogation of common law? It was created by a common law court, wasn't it?
The right to no party is entitled to fees as a matter of right.
Is it a rule of procedure or a rule of substance? Is that a rule of procedure or a substantive rule?
Well, Rule 1.525 is a rule of procedure.
Okay, and who created it?
The legislature.
It did?
Well, the old law was that the court. The old law by the legislature was that the court could award fees in a reasonable amount of time following final judgment, and the court changed it to a 30-day requirement, which is a strictly enforced rule.
And that 30-day rule was created by a common law court, right? The Florida Supreme Court.
Right.
Right?
Right.
How can a rule of the court be in derogation of the common law? I realize there's cases that say that, but how can that be?
I think what their point is that the right to fees is in derogation of is not a common law right, and so the requirement that you serve your motion for fees within 30 days must be strictly enforced because there is no common law right to fees, and that's why the Supreme Court has come back and said in Sciamotor Freight Line and Ameris Life that you must abide by this quote bright line time requirement. And the courts have been very strict, including yourself, Your Honor, in several cases out of the Second District Court of Appeals, and have said if you go outside of this 30-day requirement, there's really no discretion for the court, absent very limited exceptions that we'll talk about, but there's no discretion for the court to grant attorney's fees outside of that 30-day time period. The only relevant exception is if the judgment itself determines entitlement to fees. So the question becomes, how does the law fit into this case? Well, this was a consolidated action. There were two cases filed. The Patels filed a declaratory action arguing JVR&K was not a holder in due course under the mortgage, didn't take the mortgage in good faith. They argued on a conspiracy theory, and then they argued for rescission of the assignment documents. While that case proceeded, JVR&K filed their foreclosure action, and these two cases were consolidated. Well, what does it mean that the cases were consolidated? It doesn't mean much of anything, except for the cases were tried together. Several courts have held, and this is a quote out of
Does the consolidation order itself have limitations of any variety?
The consolidation is for purposes of discovery, mediation, and trial, and I found no case law to suggest that it makes any difference as to what it's limited to. For the Shore Supply Company case, it states that consolidation does not merge the suits into a single cause or change the rights of parties, or make those who are parties in one suit parties in another. Rather, each suit maintains its independent status with respect to the rights of the parties involved. So it's not surprising that in this consolidated case, there would be two judgments issued. The first, on February 6th, resolves the declaratory action. It effectively removes the Patels from the case. The second, on February 19th, is a final judgment of foreclosure. And the court was required to apply Rule 1.525 to both of these judgments. Frankly, it doesn't matter if it was a consolidated case. It doesn't matter if we call the February 6th judgment a final judgment, if we call it a partial final judgment, removing the Patels from the case. The language of 1.525 applies regardless because it states that a party shall serve their motion no more than 30 days after the filing of the judgment, which judgment or notice concludes the action as to that party.
Does it make any difference in a foreclosure action that the judge made some determination that the assessment of fees would be delayed till later on?
The foreclosure action is a separate judgment. That's the February 19th judgment. With respect to the February 6th judgment, there's no right to fees because Patels were out of the case, they didn't file their motion on time, and there was no determination of entitlement to fees within that February 6th judgment. No right to fees against the Patels in that case because the 30-day clock had expired. You're mentioning the February 19th judgment. The argument that JVR&K made was that certain language within the judgment of foreclosure would allow them to recover fees and avoid the 30-day time clock because the court determines entitlement. If you were to accept their argument, they would only be entitled to fees against City Center in that foreclosure action because consolidation does not merge these cases together. The language in question... Is the February 19th order, or February 6th order really? There are so many final orders in this thing. The February 6th order doesn't have the feel of a true final judgment. It orders a final judgment to be entered in a foreclosure action and makes various findings and determinations. Well, first of all, it's entitled final judgment.
Yeah, that doesn't...
And it rules in favor of the Patels on count 1, which is the deck action, or excuse me, in favor of JVR&K on count 1, which is the deck action. It essentially enters judgment in favor of JVR&K on the remaining counts in the deck action. And then it directs the court directs JVR&K to draft a separate final judgment of foreclosure. There are clearly two separate judgments. And of course, the final judgment of foreclosure makes zero mention of the fraud action because it's already been resolved. The language in the final judgment of foreclosure that JVR&K argues determines entitlement to attorney's fees reads that this court retains jurisdiction of this cause for the purpose of making any and all further orders as may be necessary and proper, including without limitation the assessment of attorney's fees, costs, writs of possession, and for entry of deficiency judgments. The court is reserving its jurisdiction to enter awards on the assessment of fees. It has not determined entitlement of fees. This is not clear enough to satisfy the Ameris test. The Ameris case says that if the judgment itself determines entitlement, then a party need not abide by the 30-day rule. But the judgment in Ameris is quite clear. The judgment said the defendant is liable to the plaintiff for fees, which are reserved at this time. The Ameris court cites Camiso favorably. The Camiso case states, the final judgment stated that it determined that Foreman was entitled to attorney's fees as the prevailing party and stated the amount would be determined at another hearing. These are clear determinations of entitlement that were not at issue in our case. Now, admittedly, the judge comes back at the hearing 3 months now down the road following final judgment and says, well, it was my intent to award fees in this case because I would always award fees in foreclosure cases. Well, there's two problems with that. First problem is that it doesn't matter what the court's intent is after the fact.
Well, that's not, the court's intent isn't going to put anyone on notice.
Correct. And the Ameris court is quite clear that you look at the judgment. And if you want to really look at the court's intent here, look at that February 6th judgment at the bottom. And what it tells the court to do, or excuse me, what it tells JVR&K to do is it says, draft me a final judgment of foreclosure and reserve the issue of attorney's fees. That was the court's intent, as expressed in the February 6th judgment. Reserve the issue of attorney's fees.
Does the final judgment of foreclosure resolve the count on the promissory note?
Does it resolve?
I'm assuming the foreclosure action is also an action on the promissory note.
Correct.
And so that that part of the case is still pending, isn't it?
My understanding is that it is not.
Because it, unlike some other things that you don't have to elect or remedy in a foreclosure action.
My understanding is that the case is over with respect to the foreclosure.
Okay. You're about 10 minutes in, so you probably ought to move to your other two issues if you don't want to run out of time.
Okay. So again, because there's no determination of entitlement to fees in the February 19th judgment, it's not clear enough. There's no right to fees under 1.525 with respect to that judgment. There's also no right to fees with respect to the February 6th judgment against the spouse. Which brings me sort of to the next problem, which is the court made all of these parties jointly and severally liable for all the fees. Consolidation does not merge these cases together. The parties still retain their separate identities. Being a party in one case does not make a person a party in the other case. As an example, American Employers Insurance Company versus J.H. Atkins and Associates, 332 7nd 348. In that case, two cases were consolidated. Defendant tried to file an answer and counterclaim in the second case. The court said you can't do that, you're not a party. So apply that logic here. The Patels can't file anything in a foreclosure action, so how can they possibly be subject to fees in that action? So the order making all parties jointly and severally liable is clear error, and it needs to go back and be fixed, at the very least for that reason.
The Patels are not and never were parties to the foreclosure action.
Correct.
Even as guarantors or anything like that, they were never added to that proceeding.
J. Guaranty is called a separate action, which is not a part of this case. The court is
Okay.
trying to enforce the guarantee agreements. The last argument I'd like to make is, even though there's no procedural right to fees in this case, there's also no substantive right to fees against the Patels in this case. JBR&K argued on two bases for fees. They argued under the guarantee agreements, they're entitled to fees because we challenged their right to enforce the guarantee agreements. They also argued under 44-1036, which is an arbitration statute which allows the trial court to award fees under limited circumstances, that they are entitled to fees. First, there's no right to fees under the guarantee agreements. There are two provisions that arguably constitute attorney's fee provisions in those guarantee agreements. One is contained in the definitional section, and it defines liabilities to include all attorney's fees, costs, and expenses of collection. The law is quite clear that if you have a narrow fee provision allowing a party to recover fees in a collection action, it has to be a collection action. There has been no collection action filed here. And those cases are cited in our reply brief. The second provision states that if the lender is required to file an action to enforce any of its rights against guarantor, then the lender can also recover its fees. JBR&K argues that under this provision, because the plaintiff has challenged their right to enforce the guarantee agreements, that they are entitled to fees. However, I think it's an important distinction that we didn't challenge the guarantee agreements themselves. What we challenged was their right to take the guarantee agreements as an assignment from SunTrust Bank. So, for example, we sued JBR&K is not a holder in due course. JBR&K didn't take the loan documents in good faith. JBR&K is guilty for conspiracy, and we argued for rescission of those assignment documents. We didn't challenge a single provision under the guarantee agreements. We agree the guarantee agreements are completely enforceable. It's just who gets to enforce them. We believe SunTrust did. Because we didn't implicate or challenge any provisions contained within the guarantee agreements, the attorney fee provision within that guarantee agreement should not apply. The case on point, Careers USA Inc. versus Sanctuary of Boca, it's a Florida Supreme Court case. That was a declaratory action in which the court did hold that in certain declaratory actions, an attorney's fee provision could be triggered in a contract. That was a lease agreement. The tenant sued under the lease agreement in the declaratory action, asking the judge to declare that, in fact, the tenant's rent would escalate at a slower pace than what the landlord believed. The landlord believed it should escalate at a quicker pace. The court sided with the landlord, construed the provision within the lease, and actually told the tenant that he owed the landlord more money. And the court held because of that, because I'm construing a provision within this lease agreement, and because it's resulting in a determination that the landlord is entitled to more money, the attorney's fee provision applies. Again, here we're outside of the agreement. We're really challenging the assignment here. And because of that, there's no right to fees under the guarantee agreements. Last but not least, 44-1036, this allows a trial court to award fees following non-binding arbitration if the losing party elects for trial de novo and then recovers 25% less in the trial de novo than in the arbitration. In this case, we've talked about this issue in a previous argument with Judge Altenberg. 0 to 0 is not a 25% difference.
We had, you're correct, we have another pending case where this argument was made, but there's no decision that's been rendered in that case, right?
Correct.
Okay.
Correct. We have gone from 0 to 0. There's no 25% difference. The legislature actually amended the statute. It used to read, if you go to a trial, you elect for a trial, you recover no more in the trial than you did in the arbitration, then you may be subject to fees. They've changed the statute to require a 25% difference. You don't do 10% worse, you don't do 15% worse, you don't do 20% worse, you have to do 25% worse. We didn't do any worse, we did the same. This is a very common scenario that the legislature would have anticipated. Going from 0 to 0 has got to be probably one of the most common scenarios possible because there was not a 25% difference. 44103 does not apply. And for these reasons, there's no right to fees in this case. J.B. Case motion was untimely. There's no substantive right to fees against the Patels, and the order must be reversed because it makes the city center and the Patels jointly and severally liable for all of the fees expended in this case.
Thank you. Save you 5 minutes for rebuttal. Mr. Sabo.
Please support Your Honor, Douglas Abel on behalf of the appellee JBRNK. Let me start by correcting one of the statements Collins Counsel's made at the end of her argument, which was that in the action tried with the trial court, there was no attack on the enforceability of the guarantees, and they only attacked the assignment. Reading from the record, page 22, which was the second amended complaint, which is the operative pleading in the declaratory judgment account, they specifically state JBRNK did not acquire the loan documents in good faith and is otherwise equitably estopped from enforcing the loan documents, which included the guarantee. Throughout the second amended complaint and the other actions in the rescission, they specifically asked the court to stop the enforcement. They were not attacking only the assignment, but they were attacking the enforceability, which is why it was critically necessary to prevail on that count, because if there had been a judgment against my client, they would never have been able to sue on the guarantees. Getting back to the first argument counsel made, the Ameris exception does apply in this case. And if you read Ameris,
let me ask you, especially when you're making kind of all your arguments here, although the cases were tried in the consolidated basis, your right to fees and the procedural process for the fees may be different for one case versus the other. So I'd kind of like to keep that distinction going if we could.
They were, however, there was clearly overlap, and let me explain why. This is not, the cases that they cite on consolidation are distinguishable. In those cases where the court said they retained their separate identity, there are clearly separate parties involved, where you have a plaintiff or a defendant, different causes of action. In this case, you had the same parties, the operative parties, suing. In fact, in the JBRNK counterclaim, which was filed in the foreclosure 6568 case that was consolidated, they asked the court in the consolidation, or in their counterclaim, they asked the court to take judicial notice of the pleading that the Patels filed, and not just take judicial notice, they realleged and reincorporated all of the general conditions of the suit filed by the Patels.
I guess and this is kind of a twofold question, it appears to me that only City Center LLC is a party to the foreclosure proceeding, and that your right to fees vis-a-vis them may be different than your right in the foreclosure case, at least, against the Patels. And then likewise, the argument about Rule 1.525 may be stronger on their part in the so-called fraud case and less strong in the foreclosure case. And that's what concerns me.
I think it's less strong for them in both cases, and here's why. First of all, we need to establish what the standard is. And I would suggest, based on the second DCA's ruling in Great versus Dames and Moore, the standard is an abuse of discretion standard. when fees are awarded, as opposed to fees being denied, it's an abuse of discretion standard.
But by what legal right in the foreclosure action could you get a judgment for fees against the Patels?
Against the Patels, if you look at the guarantee itself, the language of the guarantee, and remember,
The Patels were not sued on the guarantees.
they were not sued on the guarantees.
So how can you get a judgment against them on the guarantees in the foreclosure case if they're not being sued on the guarantees?
That's a good question. We didn't sue on the guarantees. You can get a judgment based upon the language of the note and the mortgage.
Are they parties to the note and mortgage?
They are not parties to the note and mortgage.
How can they be liable for fees in the foreclosure if they're not parties to the note and mortgage?
If you read the documents together, under the guarantee, they are liable for all liabilities.
But they haven't been sued on the guarantee.
Right, but the language
You're entering
says,
an attorney's fee judgment against someone who's not a party to the proceeding. That just seems problematic to me.
under the note and the mortgage, it says all persons or entities now or any time liable, whether primarily or secondarily. That would include the guarantors.
So when did you sue them for purposes of fees under that language? Did you name them as parties to pursue your contractual rights against them individually in either lawsuit?
And
The answer is no.
Well, no, in the guarantee action,
You haven't sued them in this case on the guarantees.
and I don't think that we had to sue them on the guarantees.
You don't have to make them parties in order to get judgments against them on contracts for which they have not been sued, is what you're arguing.
No, I'm not. If you want to separate and say they were two separate actions, I would agree with you that in the foreclosure case, they were not parties per se to the foreclosure case, although everything was consolidated and treated as one case. In the guarantee lawsuit, remember that they sued not only to...
If I am sued along with Judge Altenburn for some things we may have done, but he is sued because it was a tort, and I'm sued under a theory of breach of contract, and the cases are consolidated. If I lose on my case and he wins on his case, he can pay the fees for which I'm liable?
No, in that situation, no. That's not what we have here. The language of the guarantee specifically provides, and it's very broad language, it doesn't require us to sue.
Counsel, I understand it. I understand that. But how can you get a judgment on a non-party on a claim that has not been brought, which is to enforce the guarantees?
We didn't, the basis for the fees isn't through the foreclosure action. It's in the
So I'll jump
on the fraud case.
I'll jump to the so-called fraud case.
Right.
And
That's
then the
what I was-
question would be, why isn't that request for fees untimely under 1.525 as to that action as compared to the foreclosure?
That's where I was trying to answer with regard to the standard on an abuse of discretion. First of all, the argument that it wasn't timely filed wasn't raised in the separate lawsuits. It was raised that the motion was filed. But here's why. The court retained, when it said the issue in the, what I'll call, for lack of a better term, the first judgment, earlier judgment, when it said the issue of attorney's fees, under Ameris, the test is if entitlement has been established, the 30-day rule doesn't apply. The court explains the policy behind that, and they said that what they are trying to prevent is prejudice and unfair surprise. So if you look at whether there was prejudice or unfair surprise, and again, giving deference to the trial judge, here's what was in front of the trial judge. The trial judge had an answer to their lawsuit, the fraud case.
And let me stop you real quick, and I'm sorry to interrupt you, but what was the basis for entitlement in the fraud case?
The basis to the entitlement was the loan documents, being the guarantees and the note and the mortgage. Okay? They sued to rescind, invalidate, make unenforceable what they described as the loan documents. The loan documents included the note, the mortgage, and the guarantee. So there was a reservation of rights for fees in the answer. That put them on notice to begin with. Additionally, as part of the trial, There was a stipulated document, document R, in our appendix, that was a stipulation as to attorney's fees. It was reserved, entitlement was established. The court accepted that, and the court stated that that's why the court said entitlement had already been established. The parties as part of the trial. Now, unfortunately, we don't have the record because the appellant didn't order the record. That's their burden. We don't have the trial record, but we do have the Exhibit R as part of the file. It was mentioned to the judge in the motion for fees. He remembered it. And in his initial final judgment, he referenced that the parties had stipulated 2 fees. There was no unfair prejudice or surprise to the Patels in this case that they were being pursued for fees. In addition to it being in the answer and having been stipulated to by the parties, the documents that they sued upon themselves. Remember, they introduced those documents. They sued upon the documents, had clear and unambiguous language throughout the documents that they would be responsible for fees in the note, in the mortgage, and in the guarantees. So there was no unfair surprise or prejudice to them. In the initial final judgment, February 6th, they were on notice when the court said that it reserves on the issue of attorney's fees. I submit to you that the judge is the best one to decide what he meant by that. The cases that they cite, like Call, simply had language that said the court retains jurisdiction to enter any and all further orders. That's not what we had here. The court specifically said it's retaining jurisdiction to deal with the issue of attorney's fees. It identifies specifically attorney's fees. The court knew what it meant by that, and the court knew because the parties stipulated. How can you stipulate to attorney's fees and then turn around and argue, well, we didn't know you were pursuing us for fees? It makes absolutely no sense in this case for the Patels to say, we never knew that you were pursuing us for fees, yet their trial counsel stipulated to attorney's fees. They clearly knew that attorney's fees were being pursued in this case. It's in both final judgments.
But isn't the rule that applies that even if a party pleads for fees under an absolutely valid basis for pleas in an answer and the affirmative defenses, that if we prevail, we want to get our fees, that puts the other side on notice. But the case law says at the end of the case, when the court has decided who's winning the case, you still have to file your motion for fees within 30 days.
You do if entitlement has not been established, and I submit to you when they stipulated.
They didn't stipulate to entitlement. They, as I understand the record, the agreement was, here's what they incurred as fees. We don't object to that. That's their exhibit. They didn't say, and we know we're liable, and we know you're going to figure out the exact amount, but we're agreeing that that document is adequate evidence should you determine they prevail, and should you determine that they're entitled to fees.
I would submit to you again, Judge Silverman, isn't the trial judge the one that knows what was in his mind, what was heard in front of him at trial? They didn't order the trial transcript. What would have happened at trial if it wasn't a stipulation to entitlement? All you had to do was put somebody on the stand and ask a single question.
It seems to me to be one of those situations where perhaps the transcript might have helped you, because we have an order where the judge says, I'm reserving jurisdiction regarding the issue of attorney's fees. Doesn't say I'm reserving jurisdiction to determine the amount. Doesn't say I find entitlement to this party, but I'm reserving the issue as to amount.
And under an abuse of discretion standard, you have to find that no reasonable judge would come to that conclusion. This judge told you in the hearing what his intent was. He said, I intended.
Well, but his intent doesn't put the other party on notice. It's what's in the judgment that this court has to look at to determine whether that was adequate to put them on notice. Whether that's the equivalent of a determination of entitlement. I mean, isn't that the issue?
But the burden is on them to show, because it comes to this court cloaked with that it's an accurate judgment. And they have done nothing.
Well, we have the judgment and we know what it says, and then the question is what it says the equivalent of a determination of entitlement that would put them on notice in order to invoke this exception to the rule that you have to file a motion.
And certainly if you take each judgment separately, certainly the foreclosure judgment, when it says assessment is a defined term under Black's Law Dictionary.
As to the other case, the only judgment is this February 6th judgment.
Well, I would submit to you
Is that
that
right?
they're really not two separate judgments. If you look at the first judgment.
Just tell me, as to that.
Yes.
Okay.
Yes, Your Honor.
And that reserved jurisdiction regarding the issue of attorney's fees.
The issue of attorney.
It doesn't say entitlement or amount or anything. So
It does not
how do
say-
we know from this record whether entitlement has been even determined yet?
Well, you know, again, from the fact that they stipulated, and I would disagree respectfully that when you stipulate to something, it's not just stipulating to an amount, it's stipulating to entitlement.
So your argument is that the February 6th was a determination of entitlement.
Coupled with the fact that they stipulated at trial to attorney's fees. It's not just the amount they're stipulating to, it's that we proved what they stipulated to.
How do I know
The
from this
prima
record?
facie.
How do I know from this record that they stipulated at trial to attorney's fees?
We have the exhibit from the trial, Exhibit R, which is in our appendix.
Okay.
That is an trial exhibit. It's Exhibit R from the trial. And that was made a part of the record by us in this case. When you stipulate to a party's case in chief, and you're stipulating to everything.
Exhibit R is a stipulation between the parties?
Yes, that was
Okay.
the stipulated exhibit at trial where all that was tried was their cases. But our side of the case was stipulated to. There was no proof made necessary at the trial. And that's why the judge said in the initial judgment, in the February 6th, that the amounts were stipulated to by the parties. The judge was telling you, to answer your question, Judge Altenberg, how do we know the February 6th had entitlement? He said the parties stipulated to. When you stipulate that you proved a prima facie case, it's all elements, not just the damage.
I disagree with you. Having tried cases and the other judges having tried cases is oftentimes on an issue like attorney's fees. You stipulate that, yeah, that's a reasonable amount, that's a reasonable hourly rate, those are reasonable number of hours that have been expended, but I'm not stipulating that they're entitled to their fees. Yeah, Judge, if you determine they win and they're entitled, yeah, we're not going to contest these amounts. Why is that? Why does that? Unless, maybe, again, I'm misrecalling, but unless the stipulation is that we stipulate they're entitled to their fees in this amount, should you enter a judgment for them?
Because it wasn't just a stipulation as to amount, it was a stipulation that our case was a prima facie. We proved our case.
And the document reflects a stipulation to that effect. If they are stipulating you are entitled to fees.
It has a category. It says it has the principal amount under the interest, and it has a separate category for attorney's fees. There was no proof put on by.
Counsel, let me ask you a very direct question.
Yes.
See if you can answer this.
Yes.
Does the document reflect a stipulation to entitlement of fees, to the award of this amount of fees to your client, should your client prevail?
The document?
Yes or no?
I would argue yes. It does not say entitlement on the document. But if you take it in the context of what they were stipulating to at the beginning of the trial, what the parties did was we stood up and said we stipulate that we have proved our case. The whole case resolved around whether they could prove that there was fraud or conspiracy. That was the only.
You have proven a prima facie case.
Which would be,
And the other side then gets to present its evidence, and then the court has to determine who prevails and what they're entitled to.
that is correct. And in the first final judgment, the court specifically said, the parties stipulated. That would include an entitlement when you are proving, there's no other element to prove. We didn't introduce anything. I mean, in that case, you could argue, well, you never proved the documents. It's not just the amount. How did we ever prove that there was a mortgage or a note? It's because the parties stipulated to every element of our case in chief. That's what the stipulation was at the beginning of the case. There is no, that's an element of the case to prove attorney's fees, that there's an attorney fee clause, that's why the parties stipulated to it, and that's why the judge...
Point me to the language real quick in the final judgment where you indicate the stipulation to that effect, where the court's acknowledgement of the stipulation.
And it would be paragraph C on page 3. I have an appendix site, page 122. It says, it talks about based on the figures as stipulated into evidence by the parties.
And that's referring to a final judgment of foreclosure based on the figures as stipulated into evidence.
That is correct.
Okay, so point me to the language where there's a stipulation in the fraud case, what we're all calling the fraud case, as to entitlement to attorney's fees, or an acknowledgement that if your client prevailed in the case, it was entitled to get its fees.
It doesn't say it.
Okay.
In that respect, it says the stipulation of the parties.
Because at the top in paragraph 1 it says, JVRNK is the proper holder of the notes, mortgage, and guarantees admitted into evidence by stipulation, so there's no reference to an evidentiary stipulation as to amounts. Then paragraph 2, the court's reviewing the evidence presented and evaluating the testimony of the witnesses. Paragraph 3, the evidence presented failed to show active concealment, and so forth.
Right, and the reason it says it there is because in that count 1, they're talking about their claim against us on their second amended complaint. Our case in chief on everything was stipulated to in the case. They presented their case. That was the evidence put forth by the court. If you also look at the language of the promissory note and the guarantees as a whole.
You recognize that even if there's a stipulation on fees, the trial court still has an obligation to determine reasonableness, correct?
Yes.
And the court's got to determine reasonableness of the number of hours and the hourly rate.
And we had an evidentiary hearing on that.
Okay, so that was not stipulated to.
No, but that's not.
That's the amount. I understand. That's the
Yes.
amount issue.
The judge had an evidentiary hearing. That transcript is part of the record in this case, where they made their argument at the beginning of that, and the only thing.
So the stipulation that you're referring to was your contention as a stipulation as to entitlement, even though the court's got a document with all the figures. Your contention is they stipulated to your entitlement to fees.
It was part and parcel of it because we presented no evidence at all. I didn't present a note, mortgage.
I just wanted to make sure I understand your argument.
Yes. Yes, Your Honor.
I will let you run over, and we've asked you a lot of questions. I'd like to give you at least 30 seconds here to talk about the 0-0 on the arbitration aspect of this.
Thank you, Your
before
Honor.
sit down.
It's the same argument we made in front of you 6 months ago, that the legislature in the cases I
I
cited.
apologize that it was 6 months ago, and I don't remember.
That's quite all right. I just was giving you a time frame for when.
I'm aware that it's 6 months ago.
Thank you, Judge. It's the same argument. The legislature never intended to penalize somebody for getting the best possible result you could get in this case. And we cite 2 cases, the Lansdowne Talabisco case that came out that said even if it says exactly what it says, that you can ignore that because the result is so unjust. And I would suggest in this case that the legislature never intended that if the arbitrator, the non-binding arbitration, had said, all right, I'm going to award you $1 and then we get a 0, we would get all of our fees. We got the best possible result. The legislature could never have intended that, because if you look at the title of the statute itself is to avoid trials. That's the whole purpose. As I explained last time, it puts risk on the parties to evaluate their case. And when the non-binding arbitrator entered saying you get 0, it had to put risk on them. Otherwise, they could just roll the dice in this case, which is what they do, and that's their argument, and it makes no sense.
Okay, thank you.
Very much.
Ms. Bellenbauer? Let me ask you, in the so-called fraud suit, you were seeking rescission of some of these various documents?
We were seeking rescission of only the assignment, and the complaint is very clear. We only sought rescission of the assignment, not of the guarantees, the mortgage.
And is there any case law, one way or the other, on whether seeking rescission of an assignment of documents wherein the documents have provisions for attorney's fees, that the right to fees carries over one way or the other?
There is no case law. Presumably based on the Careers USA case, if we were suing for rescission of the assignment and we're a party to the assignment contract, then perhaps the fee provision in the assignment contract would apply. But of course, that's irrelevant in this case.
And is it your position that the February 6th final judgment had a determination of entitlement to fees in it?
The February 6th final judgment?
Yes.
Absolutely not. And I want to go back to that.
So has there been a determination of entitlement below?
The court essentially ruled that at the hearing. And I can go through exactly what.
But we don't have a transcript of that hearing.
We do. We have
Okay.
a transcript of the hearing as to fees.
At the fee hearing, you mean? Okay.
Yes. And he did. He presumed it actually went to the amount.
You're talking about the fee hearing after the February 6th judgment,
The only fee hearing that we ever had.
which was after that judgment?
Correct.
Okay, so I go back to the February 6th judgment, which is for, I believe, the fraud case, the final judgment. Is there a determination of entitlement to fees in that judgment?
Absolutely not.
Okay, if there's not a determination for entitlement to fees in that judgment, why does 1.525 apply to that judgment?
Well, 1.525 applies because if there's no determination of fees, you have to request your fees.
file a motion for fees until entitlement has been determined.
No,
Can?
no, that's not correct. I believe once final judgment issues, the other party is required to file their motion for fees, which they requested in their original answer, within 30 days of that final judgment. The only exception is if the judgment happens to do, as you say, a determined entitlement to fees. That's the Ameris Life case. And that's when the 30-day time period is waived. This is really, before I go on with 1.525, there is no stipulation. If you look at Exhibit R, this document that JVR&K is referring to, nothing says stipulation on it. It's essentially a blank document that lists principal in the amount of X, interest in the amount of Y, and attorney fees in the amount of. And it's exactly what Judge Silberman described. Our trial counsel was stipulating to the amount because we weren't going to bring in all these experts and challenge. We were going to agree with them. If you are entitled to all your attorney's fees, this is the amount that it would be. We're not going to challenge the amount. We never stipulated to anything regardless. We just let them admit it into evidence, and we didn't object. That's what Exhibit R is about, and it's in the appendix, so feel free to examine it. It was simply an exhibit that was entered into evidence below that trial. Certainly, we would never have stipulated to entitlement. We hotly contest entitlement. We don't believe the Patels are entitled, or the JVR&K is entitled to fees against the Patels in this case. And of course, we are challenging entitlement with respect to 1.525 as well. This is actually a very simple case, and I just want to make sure that it's clear. 1.525, regardless of the consolidated nature of the case, it says that after a judgment issues, which judgment or notice concludes the action as to that party, a party has to file their motion for fees within 30 days. So, February 6th judgment. JVR&K filed their motion on April 1st. That's more than 30 days after. The Ameris Life exception does not apply because there's no determination of entitlement in that judgment. End of the case with respect to the Patels. Move on to JVR&K, and then there's this issue as to whether the judgment itself determines fees. I would argue that based on Ameris Life, which carved out this very narrow exception to 1.525, there has to be a clear determination of fees within the judgment. Now remember, the February 6th judgment issues, and the court tells JVR&K, draft a final judgment of foreclosure reserving the issue for fees. We get this final judgment of foreclosure, and there's this very ambiguous language reserving the assessment of fees. There's no clear determination.
Let me just stop you for a second. The foreclosure, I don't really know whether this piece of property has been sold or not, but you can come back for a deficiency judgment.
Right.
And in part because the promissory note still stands out there. So if you can do that in terms of attorney's fees, I'm not sure why the timing flows from this initial judgment as compared to the timing for a deficiency.
I'm assuming they're just considered separate judgments. The final judgment of foreclosure is a separate judgment from the deficiency judgment.
But if this foreclosure judgment is odd in my mind because it doesn't include an amount in the foreclosure judgment for attorney's fees. We normally see that. And so you go to sale, and part of the price at sale may go to attorney's fees. But here they didn't put attorney's fees into the foreclosure judgment, which means that the right to fees under the promissory note, I think, still exists. That's what I was trying to get to before.
I would assume that they would file a separate motion for fees in a separate action on this deficiency, and that's how that would work.
Okay.
Again, 1.525 is straightforward. There's no right to fees because JVR&K's motion for fees was untimely as to both judgments. There's no substantive right to fees against themselves, of course we didn't get to argue this below. And the court's order is, if error is a matter of law, because it makes all of the parties jointly and severally liable for all of the fees spent in the case. So for these reasons, we request that you reverse this.
Okay. Thank you very much, both sides.